Ciao a tutti. This is Prof Jo at Prof Jo Explains, and this is the recap from the Caneiro trial today. And I guess I will start with, I think, the question of the day from the defense to a witness who was an employee of the computer company in which Keith Caneiro had a 90% share and was president, and Paul Caneiro had a 10% share and was vice president. The question was, did you know that Corey Caneiro lived in Keith's basement? And the answer was no. So it's an interesting question because until this point, I don't think any of us knew that potentially Corey had lived in Keith's house. We still don't know that's true because it is not evidence yet, at least. The question is not evidence. It might have planted a seed with the jury, but the answer was no. And so the only evidence is no. That witness did not know something that's not in evidence. We can only assume that the defense will follow that up with someone else or some other evidence. We do not know whether it will tie up to anything because, as I recall, on the night at least of the two fires and the murders, Corey was visiting in-laws, and I thought it was Pennsylvania, but I could be wrong about that, but he was at least visiting in-laws. And the next morning, remember, the fire was discovered around 4:30, I believe, the fire at Paul's house around 4:30. And at some point later that morning, Corey Caneiro stopped at Paul's house, and one of the witnesses said it looked as though Corey was giving Paul money, presumably money to get a hotel room or to buy meals or something. So that's all we know about Corey so far. You may remember from last week, there was a reference by the judge to a sidebar conversation among the defense and prosecution lawyers, and of course, Paul Caneiro, about third-party suspects. And our guess last week was that referred to Corey Caneiro, that the defense is pointing the finger at Corey as the person who started the fires and did the murders. Certainly not a brotherly thing to do. But, and the reason, at least the part of it, presumably part of the motive will be the same one that Keith had, which is that Corey was having financial difficulties. And in fact, I think the defense lawyer in opening may have said just that between Paul and Corey was having more financial trouble than Paul was. So that's, I think, what the motive is going to be here. And I assume that the question, assuming that there's evidence about it, and right now there's no evidence, that Corey may have stayed in Keith's basement for a while, may also point to money issues, and of course also likely points to maybe marital issues, because why would Corey be staying in the basement, whereas his wife, and I assume he has children, where are they? So in any event, that was, I think, the most interesting little tidbit of something that maybe the defense is going to make something with. I don't know. There were 3 witnesses today. The first witness was another expert on fire origin and cause, and we spent just about we spent just about the first hour this morning getting that witness qualified. I thought initially that the prosecutor was going into unreasonably detailed information about why this individual could qualify as an expert on fire origin and cause. And there he is. He's now an instructor at a lecturer at a college. He had started out as a firefighter. He went into the police officer. He went into the prosecutor's offices in 3 different counties, Hudson, Burlington, and Monmouth. And he ended up in the contiguous to the arson unit. I don't think he was ever formally in the arson unit, but he became an arson investigator with at least the Monmouth County Prosecutor's Office. He was both a fact witness and an expert witness. A fact witness because he was the fire investigator at Paul's house the morning of the fire. And so he was there as any other fire chief or firefighter or individual, talking about what they did, what they collected, how they collected it, why they collected it. And then he was also an expert witness with regard to what the fire suggested as in terms of where it started and how it started. And so he was both. So they qualified him as an expert. Experts not only have particular expertise, obviously, but it's an expertise in an area that the general public, you and I, don't have. And the expert will be able to offer an opinion that might help the jury to decide the fact questions it has to decide. Experts can offer opinions. Fact witnesses cannot offer opinions. Fact witnesses give observations. They tell you what they did, what they saw, what they heard, if it's not hearsay. But they cannot give you an opinion. They cannot say, I heard him yelling. It was my opinion that he was angry and getting into a fight, unless that's the kind of observation that any of us could make. But if it's specialized knowledge, then that individual who's a fact witness cannot give an opinion. Expert witnesses can give opinions. It's still up to the jury to decide how much weight, that is, how much they're going to rely on what the expert says, or not, or a little. And the jury ultimately is the fact finder. And in New Jersey, or at least in this judge's court, every time an expert is qualified, he gives that instruction to the jury again. So he must have given it 6-7 times already. I think some of us might be able to almost recite it by heart at this point. So this witness talked about finding blood in the kitchen, a couple of places in the kitchen. And his testimony was really horrifying and so sad, because one of the places where there was blood was the 11-year-old boy. And apparently that child at least moved some because there was a blood trail. So it was just really terrible. And, to try to contemplate what was going on and what the child knew before he was stabbed to death it was just terrible testimony. After this expert witness, we had an employee of Paul's company, or Paul's and Keith's company, mostly Keith's. It's the company, the computer company, and there he is. That was 90% Keith's, and he was president, 10% Paul's, and Paul was vice president. This witness installed security equipment at Keith's home and upgraded the equipment. And he's the witness who testified that when he had an alert from Verizon that the power had gone out at Keith's house, he phoned Paul to tell him that the power was out. And Paul evidently said something like, my house is on fire. So it was ready at the time that Paul was at his house and they had discovered the fire at Paul's house. This witness really, I don't think, offered much more than that, except that he was the witness that the defense lawyer, to whom the defense lawyer asked the question, did you know that Corey was living in Keith's basement? And he's the witness who said no. So that was that witness. And then we went to the third witness today. The third witness was a canine officer, and he talked about his partner, and his partner was the dog. So it was I found him charming the way he described his relationship with the dog. He was very interesting in terms of how they train a dog to become a cadaver dog, what they call a cadaver dog. And it's a lot of training to get them up to speed in the first place. And you have to work with the individual trainer because they essentially establish a bond. And he said that what happens is, you train the dog to recognize the smell of a dead body, of blood, of, maybe decaying body parts, and they'd keep doing it and keep doing it and keep doing it. And every time the dog gets it right, the dog gets some sort of treat. And so the tells on the dog, a trained dog, as to when he is alerting that he has smelled somebody something, whether it's a body part, excuse me, or the scent or blood or whatever, is that the dog gets very excited the way the dog would get if the dog realized he was getting a treat. His mouth closes because, again, that's what a dog does when a dog thinks he's getting a treat. His tail wags, again, the way a dog would if a dog was getting a treat. And this canine officer said, and the dog can't make it up. When those things happen, the dog's, body chemistry and anatomy take over, and he gets excited, and those are his tells. And this dog, when he's really close, scratches. And that's when this officer knows that the dog has decided he's can't go any farther. This is the place. And so the dog alerted to blood near the island in the kitchen, at another spot in the kitchen, and then in the basement, they called it a cabinet or closet. And that's where this officer said the fire started. It was the area in the house with most fire damage and debris. And they work from outside in. They work from the place where there's least fire damage to get to the place where there's the most fire damage. And he testified that what happens with a fire, and which is why this fire, although it had been set earlier, didn't really go off until later, was that it was in a contained space. The oxygen had been pretty much sapped out. So the fire was there and smoldering, but it wasn't doing anything. At some point, when the heat was enough that the ceiling started to cave in, so there was more oxygen coming in, that fed the smoldering flames, and the fire took off at that point. And that's when the fire started to spread through the house, and that's when the fire was noticed by the neighbors. And that's the basement. You can see what the damage looked like, and the structural damage there. So he was really interesting in describing the structural damage and what they do when they're looking, when they're searching for a fire, and how they investigate the fire. And he said they eliminated all other possibilities. They eliminated the possibility that the fire had started by an accident, or that it was a spontaneous combustion that had started the fire. They didn't see anything that would indicate it wasn't electrical. The experts on the electrical and mechanical pieces of the house had already said that's not where the fire started. So they eliminated all the other possibilities, and they concluded that the fire was incendiary, which means that it was purposefully set. And so that was his testimony. That was his opinion. I thought he was very, very forceful and very persuasive as to the fact it was an incendiary fire, and it had started in that closet in the basement and then took off from there. And that there was a period of time where it was contained before it really took off, when the ceiling had started to cave in, oxygen came in, and that's when the fire really went. But up until that time, it was heat and it was smoldering, but it was in that small little area and hadn't gone out anywhere. Uh, the lawyer who questioned this witness was Mr. Murray from the public defender's office, and not the woman public defender whose name I don't know whether I forgot her name, which I do, or whether I just don't want to remember it because I find the way she does examination to be annoying. And he tried to get from the canine officer information about what the crime scene investigators had collected, maybe what their preliminary conclusions were. And the canine officer kept telling him, I'm a canine officer. I deal with the dog. And as soon as the dog alerts and says, this is where you're likely to find something, I'm done. Everything after that is somebody else. And this defense lawyer tried maybe 3 times. He finally gave up. She, I think, would have tried another 20 times before she gave up. But anyway, he was the last witness. Court ended for the day at around 3:20, much earlier than expected. The judge said, the reason was with the snow day yesterday, that the witnesses and the order of witnesses that the state was going to call was disrupted. And I'm sure that's true, but I still don't understand why they couldn't have, yesterday rearranged schedules. It may be that people had to come in from somewhere else and they weren't able to get in because of the snow. So the ability to substitute somebody out of order was just not really available. So we ended early today, and we'll be starting at 8:30 tomorrow. So that's pretty much everything that happened today that I wanted to reference. We didn't have the wrap up last week because the court ended really early and surprised everyone. I wanted to say last week that the thing that I didn't mention was the number of guns and rifles that Paul had in his house. It was a very large number of handguns. I think he had 12 or 14 rifles and a shotgun. And then he had more than 1,200 rounds of ammunition in the house. So a lot of firepower. He also had a bulletproof vest, and he had a laser gun. So that saves you having to use bullets, but you can practice with this laser gun to get to be a better shooter, but you don't have to waste your bullets. Apparently, bullets can be expensive. So that was really last week, the one thing that I recall that was really kind of interesting about the trial. So far what we know is the trial at Keith's was probably started earlier, but it wasn't observed until later. It was a major fire. The house was really devastated with the flames, and as I understand it, they didn't try to rebuild the house. They just took it down. So you only had the property, and then I think maybe they sold the property. The fire at Paul's house was much more limited. There was a fire on one side by the garage, which was really a very small fire, and they were able to put it out pretty handily once the firefighters arrived. The fire on the other side of the house started in the basement, and it didn't take very long to be put out. And let me say, because I think I may have been a little confusing. Should have been clearer as I'm now sitting here thinking about it. The fire, if expert on fire origin and cause today, was at Paul's house, not Keith's house. So when he found the blood in the basement, he found the dog alerted, and there was a pile of debris. And when they sort of pulled it apart, they came across what they believed to be was a pair of jeans with blood on them, and maybe another piece of clothing. So that was what the dog alerted to in the basement, and nothing on the second floor. And I believe there was the blood in the kitchen on the first floor was what the dog alerted to at Paul's house. So that's really it in terms of what happened today. We're going at a very slow pace. The prosecutor is doing a very good job, very methodical, very let's cross all the I's. No, let's cross all the T's and dot all the I's. I'm doing a really good job, probably more than he needs to do. And I really felt that way today until I realized that the defense was going to challenge the credentials of the expert, which is what the woman public defender did. She challenged the expert's credential. So the state had to put in a really detailed case because of that. So I've got a question from Sanders 14. Has the DNA and forensics come in yet? No, nor the ballistics for that matter. And if you were able to join me at 5 when I had my guest was on with regard to Matt Murphy. He's 24 years of prosecutorial experience in California, and he was talking about how ballistics, the science of ballistics has just taken off by leaps and bounds in the same way that DNA did a few years before, and that now what the ballistics experts can tell you about which gun it was that fired a particular bullet is far and away more than they could have said 15 or 20 years ago. So the ballistics evidence has not come in either, and it appears as though the bullet in the that was found, a couple of bullets that were found are going to be able to trace to the same gun that was Paul's gun. So that will be coming in. Okay, why did the defense fight so hard to keep out the fire examiner's testimony? I don't really know. I don't know that the fire examiner said very much. They're not quarreling. They're not saying it was a natural fire. They agree it was arson. So to fight about the experts saying it was arson, I don't understand. The only thing I can imagine, and it's pure guess, is that no, I'm going to take it back. I don't know why he's doing why the defense fought it. Maybe we will find out, but I do think that the defense goes after things without really having much of a idea of what she's eliciting and where it's going to lead. It may just be what defense lawyers often do, and that is just throw a lot out there, hope something sticks, and it's enough for one juror to be confused enough to say, hey, I've got a reasonable doubt. That's my best guess, and it's not really a very good guess. Okay, Jennifer and Tally, if you cannot witness to something you heard because it might be hearsay, can you always witness the fact that you saw? Yeah, what you see is not hearsay. Hearsay is a statement made by someone not on the stand that doesn't come in, and there's no exception for it. You can always testify to what the defendant, the party, the opposed party said. That's not hearsay. That's an admission by the party. So you can always get that in to the extent it has some relevance to the prosecution, to the trial. You cannot get in a statement from someone else because it's hearsay unless there's an exception. Sometimes you can get it in because it goes to motive. Sometimes you can get it in as an excited utterance. In other words, what the person said, the person was so excited and so worried and so frightened, and it was just, in the space of a moment said it, and so it has independent reliability. So there are ways to get in hearsay. But hearsay is what somebody says. What you see is not hearsay. And you can talk around it. I mean, I can ask, were you at the house? Yes. Did you talk to George? Yes. Don't tell me what George said, but what did George do? What did you ask George? That's not hearsay because it's the person on the stand saying this is the question. Then the next one would be, what did George do in response to what you said? Not hearsay. What George did that you saw is not hearsay. So, there's sometimes when you can pretty much get in what you want to get in without actually getting the statement in. Why did the defense attorney try to make this guy look dumb? Which guy are we talking about? There were the canine handler. I don't think he was trying to make the canine handler look dumb. I think he was trying to get the canine handler to say something about what the forensics people did, what the scene investigators did. And the canine handler kept saying, I'm a canine handler, nothing else. So it may have sounded as though, he was being sort of belittled or ridiculed, but I don't think that's what the intent was. He was just trying to get out an answer from the canine handler that really the canine handler was not in a position to answer. Okay. Any other questions about what happened today? I mean, it was a short day, and the first hour was spent getting the expert witness qualified, and then we took a break right after that. So court started at around 8:30. We didn't finish getting the expert witness qualified until about 9:25. Then we took a 15-minute break. I think we started again at about 9:45. And then the canine expert, the first witness, the expert on the fire testified, and the prosecutor went through what he had to say very methodically. And then we had lunch, and then there was cross-examination. And then we heard from the employee of Keith and Paul's company. He was not on the stand very long, and he didn't really have much to contribute, except that he was the one that put the security system in, and he had gotten the Verizon call when the power went out and had called Paul. And then we ended with the canine handler and the very short cross of the canine handler. And then it was 3:20 and court ended for the day. So that's a recap of the whole thing. I mean, we moved a little. We are inching along. Luckily, we're inching forward, but it's still only inching. And I keep hoping we're going to start reaching maybe a footing along, but we haven't gotten to footing along yet. We're still inching. Are there other questions here? I don't see any other questions. So otherwise, we're all copacetic, because I don't want to keep anybody longer than, what we should be doing. And if there are no questions, we can pretty much end and start up tomorrow morning at 8:30. Let's see. Nope. Okay, let's see. Why did prosecutors not name the victims, dehumanize them, show how they panicked? I don't know. What that references to is there was some discussion of whose body was where, and the witness just talked about sort of the victim without naming. I think maybe the reason is we have not yet had a forensic, lab person identify whose blood it was at those different spots. And until you do that, you may not be strictly speaking, you can't name the particular victim, because until the expert comes in and says this is the 8-year-old's blood, you can't really talk about the blood belonging to the 8-year-old, even if you have to wait for it. They could have done it and said, we'll connect it up later, and that might have been okay, but they didn't choose to do it that way. Okay, write your murder mystery set in the 1980s, no cell phones. Now that is a way to do it. Just put it back far enough that no cell phones, no DNA. That's not a bad idea. That may be the only way to get the thing written. Okay, 1016 Debs. New news about Tepe murder. What's the new news? Really new news about the Tepe murder? Well, tell us. Don't just say there's new news and leave us hanging. This is a very rude thing to do. What could the new news be? If I'm reading that right, maybe you don't mean that there's no news. You want me to close out with another pet peeve, LL Diedrich? I don't know that I have a pet peeve ready. I'm going to have to think about it a little. First, let me see if there's new news because I'm just intrigued now. Let's see. Well, what we know is court documents showed that the ex-husband, Michael McKee, had stalked the couple and was on their property weeks before the December 30 killings. And he apparently also threatened Monique about killing her and moving next door. I suppose the order would be the other way, moving next door to her and then killing her. This is from court documents. We don't know what is in the court documents or whether the court documents are hearsay themselves, but this is the information. And that McKee was seen outside the Tepe home in the weeks prior to the murders. And the prosecutors say they have other things that they can tie him with. Well, he's going to be another one of these people who don't do, are not very good at doing their murder. Thank the heavens, right? Okay, revealed that he was in contact with her since the divorce and threatening her on their property. And when you're involved with some crazed person like that, it's really, I don't want to say it's hopeless, but no matter what you do is risky. You ask for a restraining order or protective order, that can set them off. You do nothing and then they feel you're ignoring them and that sets them off. You try to placate by responding and now they think you're just leading them on and that sets them off. I mean, you need to be really careful about the people that you let into your life and get close to, because it can be somebody who is really a predator, a psychopath, a schizophrenic. Well, no, schizophrenics don't usually kill, but somebody who's really addled on drugs, and you just don't know what may come next. And it's a real tragedy when it happens. And it's really sad in her case because she tried everything she could. She let him have whatever he wanted in the divorce. She didn't contest anything. She moved away, and still, look what happened. And it's Brian Enton who has the scoop. He's a really good journalist. And he's on the ground. He goes from, location to location. Okay, Deborah Guzman said the Matt Murphy interview was stellar. He's a really great guest, and he's very knowledgeable, very interesting, fun to talk to. I'm glad you enjoyed him. And I enjoyed him a lot, in part, as I said earlier, because I agreed with him, and I always enjoy talking to somebody with whom I agree. Let's see. Do I think the judicial system can do anything to stop this? That's quilting, quilt gal. Stop what? I don't know what this refers to. I'm sorry. If you mean the stalking, they can get an order. But as I said, when you're dealing with somebody like that, there's a point at which the system, is just really not able to help. Just as she was not able to help. She moved away. She gave him whatever he wanted. And it still wasn't enough. You just have to be really careful not to get, involved. Sometimes you don't have a lot, the little spidey sense is usually pretty good. Sometimes maybe you don't have that. But in this case, she did have some indication because he had threatened her before they got married. And I think they were on again, off again, and she married him anyway. And I'm not victim bashing. I'm not blaming her. I'm just saying that you need to be really wary because, once you're in the situation, extricating yourself can be very difficult. That's why there are these shelters for victims of domestic abuse where you don't know where they are and you don't have an address. It's to protect them from the other spouse. So, okay. Let's see. You'd love it if I would replay and comment on the Charlie Adelson trial. It was a really interesting trial. Oh, you want us to go through and watch the trial again? There are so many trials going on now. I don't know when we would fit it in. It's not a bad idea, but where would you fit it in? What would you give up in order to sit through Charlie's trial again? You know, it would be tough. We are going to watch the appeal. The appeals, I believe, on February 3rd. And we're going to talk to the people in the chat this morning about what I was thinking of doing, which would be to break off doing the trial to watch the appeal and then come back to the trial. And the only comments I had was, yes, do it. So that's what I'm planning to do. So we'll see the appeal. And I've said before, I did a video on the issues in Charlie's appeal, and you can get it on YouTube. It's posted there. And that would give you a refresher, not of the entire trial, obviously, but of the issues that actually got raised in appeal. So I don't know that I see. Here's enjoyed my appearance on SDS, watching the Banfield murder, and Banfield is supposed to testify. You wonder if he's going to come across as a know-it-all like Charlie. I don't know. I mean, I haven't seen him. You know, with Charlie Adelson, we had gotten a fairly good sense of him from the emails, and you know, his appearance on the phone calls that were recorded, and what other people said he said, and from the videos. But I don't know. We don't have that sort of background on Banfield, so it's harder to say what he would be like on the stand. What's even harder to say is what in the world he's going to testify to. I mean, is he going to say the au pair did it and he was kind of protecting her? But then how do you explain, was Joe Ryan the person that they lured into the house and killed so that they could blame him for the murder? Do you say that his wife really did go on one of those websites and look for somebody to come in and violate? It would not be a rape in that case because she would have given consent. It was going to be a play situation in terms of her not, in his mind, not giving consent. But if so, is he going to claim that was actually accurate and that's what she had done? But the person who came into the house either was crazed to begin with or got crazed when he was there, decided to kill her, and that the original story they told, that he then shot him to death, but it was too late to save his wife. And yes, he had the affair with the au pair, but what she's saying now is not the truth. And she's only doing it because she wants to get home to Brazil. She's been in jail for a couple of years, and you know, she ultimately gave in, was willing to say anything just to be free. I know, is that what he's going to say? I don't know. I think his story on the stand, if he gets on the stand, I'm still not sure he will be remarkable to hear. But I won't believe it until he actually gets on the stand and starts talking that he'll do it, because it seems to me to be not a sensible choice to make. And so to get back to the question, I don't know if he's going to be as obnoxious as Charlie or come across the same way as arrogant, because at least I don't have any picture of what he's like generally. So anything else? I've been looking at these little comments and I guess I don't see anything here. Ms. Joe is a busy bee. Yes. And have you ever noticed when you say busy bee, that the busy sounds like the bee? The zzz. If you hadn't noticed it, now you can sort of tuck it away as some little observation that won't mean anything in your life, and you'll probably never be able to use it again. So you want a pet peeve, and I'm not sure. I mean, I have a million of them, but when I need one on the spur of the moment, it doesn't come up when it should. So, and some of them I've already given. I'm just going to have to fail you and not come up with a pet peeve right now. Maybe I'm just not in a querulous enough mood to be able to, think of them. Nope, I'm just going to have to fail you. Sorry. I wish I could do it for you, but I just can't. I need a little time to think about what the next pet peeve, because the only ones I can think of right now are grammar pet peeves, and I think I should space those in sparingly. And I did one, so I don't think I'll do another one for at least another month. So, okay, nothing else? Oh, thank you, quilting girl, quilt gal. I appreciate that. That response about talking too much with Matt, I got a comment that said the person wanted to hear more from Matt, which I could understand. He was really interesting. And so I apologized because I did not want to dominate. When you're doing an interview, you really need the interviewer to talk. But he was really interesting. And there were a couple of things that I thought were relevant. And in one place, I thought it was would be fun because it would move the conversation. But I did talk more probably this time than I did in the other interviews. So that was certainly true. And so others have said that it wasn't too much. And I appreciate that because I don't think an interview should be the interviewer. The interviewer should be the person interviewed that you hear from and learn from. So, but thank you. So, okay, if you can hit like, I've looked now, I don't know this YouTube stuff at all, but I noticed that of the people who are on the chat, maybe 8 to 10% hit like. And I don't know whether that means the other 88 to 92% didn't like it, but they stuck anyway, or they just can't manage to hit the like button, or they just don't think it's anything, that they are comfortable doing. If it's the latter, then don't hit like. But if it's just, that you just don't think about it, it does help the algorithm. And if you're not a subscriber, it'd be nice. I would certainly appreciate if you think about it. So, okay, I will see you all, or not all probably, but I will see some of you tomorrow as we plod along with this trial, inching along instead of footing along. And I'm sure we're never going to yard along now that I've made verbs out of two things at least that never in their lives thought they were going to be verbs. Okay. Ciao a tutti. This is Prof Jo at Prof Jo Explains signing off.